So you agree to breaking and entering into his home and getting his baseball cards out, is that correct?
No,
Well, you went into his home uninvited, is that correct?
I had access to the place.
Okay, but you didn't have permission to
I
be there.
had
Yes or
the
no?
code.
Did you have permission to be there?
I didn't talk to him that day before I
Okay.
went in.
So the answer to that question is no, I didn't have. Sides of this Rule 60 motion to vacate the judgment, one of which is the whether or not the final decree, which included the marital dissolution agreement and the parenting plan, were equitable. This court is saddled with the burden of making sure that when a marital dissolution agreement is entered, and the parties, granted the parties have agreed to it, is equitable in nature. First and foremost, I would submit to the court that there is absolutely no way that this marital dissolution agreement is equitable. And I will go through the reasons why, but then we back up into the Rule 60.02 motion to vacate the judgment, which relies on fraud, misrepresentation, mistake, and inadvertence. Specifically, the court's going to hear testimony about Mr. Dunham being given information by the wife regarding what he was signing. There's going to be information that the wife said represented that she's not going to hold him to all these things. She's not going to make him, she was going to withhold visitation of their children until he signed these documents. It's inducing him to sign it. The things surrounding the circumstances of him signing this document would in and of itself show this court that the entry of it was fraudulent. Him signing it, her signing it, her representations to him were fraudulent. So we're asking the court on that basis to set it aside. In outlining the issues here, the court's going to see that Mr. Dunham was in the marital dissolution agreement, was saddled with the mortgage that was $2,300 a month, spousal support at almost $1,800 per month, utilities at the marital residence of $350 per month. That's an approximation up and down depending on whether or not they're using their heat and air conditioning. The wife's cell phone bill and the children's cell phone bill of $360 per month. He was saddled with the expense of all the kids' travel ball expenses, which in and of itself, looking at it from the outside, wouldn't have necessarily been inequitable, but he was also saddled with the gate expenses for entry into the travel ball tournaments for the wife. He was saddled with the wife's hotel expenses, which can accrue quickly when you're in a travel ball season. He was saddled with the expenses of homeschool. The travel ball expenses broken down over a yearly basis would range between $200 to $300 per month. He was saddled with homeschool expenses, which were $208 per month broken down. It's $2,500 per year. He was saddled with the wife's car insurance, which is approximately $100 a month. And he was expected to pay child support in the amount of $1,460 a month. That is equivalent to $6,766.16 per month. His monthly average income ranges between $6,362, which is $400 less than the amount he owes the wife, to approximately $7,500 per month. So he's hitting about the $6,800 a month range for income, and that's gross. That's before her health insurance is taken out. That's before the kid's health insurance is taken out of his paycheck. So when the court's looking at this, he doesn't have $10 to spend to put a roof over his head every month. So the marital dissolution agreement is not equitable in any form or fashion, and it absolutely saddles him with every expense of the marriage, and it has him responsible for paying all the debt from the marriage. There was significant debt in the marriage, and he's responsible for paying all those, which is not included in the monthly amounts because frankly, he's not able to pay those right now. So we're asking the court just to look at this from an equity standpoint and set it aside on that basis, or for the court to look at the circumstances surrounding his going to the UPS store and signing the signature page, but not getting to look at the document. That's our position, Judge.
All right. Mr. Hawley, you wish to make an opening statement?
I do, Judge. Take issue with several of the things that Ms. Dookie just said. First of all, though, the Rule 60.02, set aside, alter, amend, I don't think it's appropriate to set it aside. Part of what Rule 60 says is it has to be a reasonable time. Now, this was all done in November, is when he signed everything. And he's had ample time to come to court and file Rule 60 until he filed it. Whenever he filed this thing, Judge, the evidence is going to show that he's started a new relationship, he's got a fiance, there's issues with the expenses and them planning whatever they're planning. But nonetheless, the reasonable time aspect of the 60 to set the whole thing aside is just not accurate. We take severe issue with the way that Ms. Duke says that and is going to portray that this was executed by the parties. Mr. Dunham had this ample time. Mr. Dunham had a lawyer at the time. If you go back through and look at the file, he had retained, and we had started out in a contested arena with this, he had retained Ms. Roberts, one of the most experienced and well-known divorce lawyers in our jurisdiction. And he had, during this time, sent Ms. Roberts, it puts me in a little bit of an issue, but he sent Ms. Roberts a termination letter, which is going to be introduced into evidence today, basically saying that he didn't need her help any further and that he had already made up his mind what he wanted to do. You can read his own words when I introduce it. And, he wanted to sign, we'd come to an agreement, and he wants to sign this thing. From dealing with this, that was, you can look at the date of the letter. Ms. Roberts didn't necessarily get off of his case, I don't think, until it was about December the 7th is when she had previously filed a motion to do visitation, temporary support, temporary motions, things of that nature. And that's when she withdrew. So there was a kind of an extended period of time in there that they were talking about it, thinking about it. I can only imagine what Ms. Roberts was telling him about making an agreement. She wanted to look at it, all of those things, but he wasn't having any of that. He sent her that termination letter, demanded that we reach the agreement that we reached, and was wanting me to do the paperwork. That's when my office says, I can't talk to you, you've got a lawyer. And then he figured out, do the termination letter, and that's what he did. So when that happened, he sent me a copy of that. We did the MDA, he got a copy of the MDA, and they met. The testimony is going to be at a place before that. He actually requested a change or two to it, and she came to my office made the changes, and I would not let him, as most lawyers, sign it in my office. My standard protocol, as it is with most lawyers, Your Honor did this for years, I let my client sign everything down there, but as far as the other side goes, you need to go somewhere else and have it notarized. That's proof that I wasn't anywhere around and had anything to unduly influence anybody to sign anything. So they met down at the UPS store, and that's where it got signed and got notarized and whatnot. So there was nothing unfair about the execution of this agreement in any manner whatsoever. This was totally his choice. He's a railroad worker. The testimony is going to be he's an engineer for the railroad. The pay stub's going to show, and the proof's going to be from Ms. Dunham He well makes in the $90,000 range on a yearly basis. That was before a rather large raise that he got back when the parties were having issues and had kind of gotten separated. He got quite the raise beyond that. He's taking FMLA and a lot of time off from work to get the pay stubs down to where they are today, I think. But his previous salary and when he was married to her was more than accommodating for this. There's another big issue, the court will hear this, he's saddled with all of these things. Well, he's saddled with the mortgage and the utilities and the taxes on the property. And if you look at the MDA, it's in two different places. But in the other place, it says that the wife's responsible for making out of the spousal support to her the mortgage, the utilities, the taxes. And that's what she had been doing. In fact, when he stopped, and you'll see there's a little, well, I'm going to pay what I'm supposed to pay, and then I'm going to pay, I think, $750 for a couple of months. Now he's down to paying her only $500 a month. She got quite behind on the mortgage. She had, and the testimony is going to be, sell some of her own property to get the mortgage caught up. And it is caught up, as of today. So to sit there and say that he has that plus spousal support is unfair because he doesn't. Ms. Dunham was the economically disadvantaged spouse in this situation. The court's going to hear that she was unemployed, homemaker. She taught the kids, homeschooled them through a curricular program, and was there every day doing that. And that's what the parties had set up, and that was the way that they had arranged for the kids to be treated on a day-to-day basis with their schooling and whatnot, and that was her responsibility. So she didn't work. If they weren't going to be homeless, all that had to happen. So sit here and say that, yeah, spousal support plus mortgage and everything, that's not the case. Ms. Dunham very conscientiously used the spousal support to make all of those necessary payments to keep the boat afloat here, until the kids can get a little older, she can get a job, start figuring some things out or whatnot. So that was all by choice. And he had the choice, on that day not to sign it and to turn away, but he did not. He went and reviewed everything. He had the documents, he reviewed them. He asked for a change, the changes were made, and that's when he agreed to all that and signed it. For that to be some sort of issue as to set this thing totally aside, we disagree with that. The child support's ran per the guidelines. There's no upward or downward deviation. That is what it is. And the spousal support is more than appropriate for the mortgage, utilities, taxes, and the expenses and the day-to-day curriculum that these young these young children were going through. To take on the livelihood of the children and Ms. Dunham. So all those funds were necessary. You'll see text messages where he agreed to that. He wanted that to happen. He wanted to support the children, and all of those things. So I think what the court's going to find today in closing, he got buyer's remorse. He's got a fiance. They've already taken I know they're taking one vacation, let me put it that way, together with the children, somewhat we'd say in violation of the Section J of the parenting plan, but he's already done that. And my understanding is it's a fiance situation, and it's where he's wanting to move on, but he needs to take care of his obligation here with his first wife and his children, before he does choose to do that. And these finances that apparently Mr. Dunham was, quote, saddled with were more than appropriate, and just basically to keep the party's lifestyle the way that it was.
All right. Ms. Duke, you may call your first witness.
Judge, I'd call Mr. Dunham.
Mr. Dunham, if you'll come around here to the witness stand, raise your right hand and be placed under oath. Have a seat.
If you would, please state your full name for the record.
Michael Gregory Dunham.
And Mr. Dunham, you were married to Miss Dunham.
Yes.
And did the two of you go through a divorce back in, the divorce was finalized in March, is that correct, of 2024?
Yes.
Okay. And in November, did you sign a marital dissolution agreement?
Yes.
Prior to signing the marital dissolution agreement, did you have the opportunity to review the marital dissolution agreement?
No.
Okay. When you were presented with the signature page to sign, was that the only page that you saw?
Yes.
Okay. And what had Ms. Dunham used in order to get you to sign that?
She just said that I couldn't see the documents because they're at her lawyer's office. And she just said she told me what was in it and stuff. And she just said I just needed to sign it or she was going to not let me see my kids.
Okay. And so did
Pull that
she,
microphone towards you a little bit there.
so did she use your children to have you sign this document?
Yes.
Okay. Did you get to see them after you signed it?
Yes.
Okay. How long had it been since you saw them when you actually, after you signed it?
It had been about 3 weeks, 2 to 3 weeks.
Now, in that final decree of divorce, let's address a few of the statements that Mr. Hawley made first, just so that we get that cleared up.
Okay.
When you signed this and realized that you could not make ends meet in order to handle the expenses that that you were given in the final decree and marital dissolution agreement and parenting plan, did you start working towards finding money in order to hire a lawyer?
Yes, I pretty much sold all the valuable things that I have, and my mom ended up having to pay for the lawyer for me. And I did have another lawyer, Miss Roberts, but as he was saying, she had an illness. Her mom was ill for like 3 weeks. I could never get a hold of her. And
Is that when you couldn't get in touch with her, is that when you tried to handle the divorce on your own?
yeah, and I actually went through Miss Dunham too to try to, 'cause I'm not real savvy when it comes to this stuff, so I even asked her what I should do.
Okay. And you don't necessarily fault Miss Roberts. Her mother was ill, is that
No,
correct?
no, I don't.
But at that time, because of her mother's illness, were you able to get into court to get your visitation set or anything like that?
I wasn't able to do anything, and the reason why I sent the termination letter is because in the middle of all that, Miss Dunham broke into where I was staying and took all my valuables, about $20,000 worth of stuff, and then I just gave up. I thought, I don't have a chance. I just said, I said, Mr. Robert, I don't need your help no more. Once she called me after that happened a few days later, and I'd already signed the papers, and at the UPS store, I just said, I'll just sign them, but they had any help.
Okay. And in that paperwork, well, let's do something else. Mr. Hawley alleged that now all of a sudden you've decided to take FMLA and you've lowered your income so that you can't cover this. When did you start using your FMLA?
2014.
Okay, is it based on a disability?
Yeah, I've got high blood pressure, and with my job, it's pretty stressful sometimes driving a train, and so my blood pressure goes up, and so I have to keep an eye on it.
Are we
So I
referring
think-
by FMLA to the Family Leave Act?
Family Medical
Yes,
Leave
sir.
Act, yes, Your Honor.
And then in 2019, before I became an engineer full time, I was a conductor, and I hurt my arm real bad, and I was out of work for 5 months, 4 or 5 months, because I had to go through physical therapy. So I got it for that too. A lot of times my arm's messed up.
Do your arms stop working where that you actually cannot physically do your job?
It did sometimes, yeah.
And were you approved for FMLA?
Yes, ma'am.
Okay. Did Miss Dunham encourage you to go through with the FMLA process?
She's the one that told me to get it.
Okay. And have you been approved as late as, the onset of your condition was back in 2014, is that correct?
Yeah,
All right. Polly says that all of a sudden you decided you can't pay these things because you have a significant other. That's not accurate.
no, because that just happened in August. This has been going on for almost 2 years, about a year and a half.
So, if I may, Judge Approach.
You may.
FMLA paperwork.
Yes, ma'am.
Okay. And does it confirm that you've got issues with using your arms?
Yes,
Testifies to what his problems are. That document.
The objection is to the hearsay of this document.
Judge, he can have it entered as having received it as his document. It can be used for identification purposes also. It's not hearsay for that purpose.
Well, I'm going to allow it over the objection because if it is in fact some sort of confirmation of the fact that what he's testified to, that he is receiving family medical leave and has been approved for it, then I'm going to allow it to be introduced for confirmation of his testimony or corroboration. But I will accept it for that limited purpose only. Overrule the objection.
Judge, I'd submit that as the first marked exhibit.
Mark it as Exhibit 1.
Throughout your marriage, did you use FMLA regularly?
yes,
Okay, and was that ever an issue with Miss Dunham throughout the marriage?
no,
Okay, and now is this the first time you're hearing that it was an issue?
yeah,
Okay. In the final decree of divorce, which kind of speaks for itself, we're going to go through the issues that are in it, was Miss Dunham awarded the marital residence and all the equity?
yes,
Okay, and how much equity approximately was in your home at the time?
$170,000.
Okay, and did you get any portion of the equity of that marital residence?
No,
Okay. Were you required to continue paying the mortgage until she refinanced or your kids aged out?
yes,
Okay. And the mortgage is how much per month?
2337,
Okay.
I'm sorry,
And
how much?
2,337.
Thank you.
You're welcome.
you heard Mr. Hawley say that you all of a sudden are not, that you make upwards of $90,000 a year, and now all of a sudden that you're not making that. Was it a surprise to you that he said 90?
Yeah, because the divorce decree says 120,000.
And at any point in time, have you made $120,000?
I've only made 100,000 one year.
Okay.
And that was-
And so was that a misrepresentation to the court by Ms. Dunham?
Yes,
The most you've ever made was in 2023, is that correct?
yes, ma'am.
Okay, has your salary over the year kind of gone up and come back down?
Yeah, it's about 80,000 on average.
Okay. Were you also required to pay her $1,787.50 in spousal support per month?
The total is 3,000 a month, yeah. 1,700, yeah.
And were you required to pay all of the utilities at the marital residence?
Yes,
Do those average out to be about $350 a month?
yes,
Were you required to pay the cell phone bill for your children and for your wife?
yes.
How much is that bill per month?
360,
Okay. And do your kiddos play travel ball?
yes,
And as a part of playing travel ball, I can assume that there is an expense to pay the travel ball team.
mm-hmm, dues,
Is there an expense for uniforms?
yeah, equipment,
Are there gate fees that you've got to pay
yes,
when you go to tournaments?
yes,
And are you going to tournaments regularly with these kids?
yes,
Did the marital dissolution agreement also require?
yes,
In your mind, does that total up to be upwards of $2,400 a year?
yes.
Sustained, don't leave the witness.
I was just trying to get through it quickly. We've got our list here. Tell me about how much you're spending on that per year.
About $2,400,
Okay. And are these kids currently homeschooled?
yes,
Okay. Well, are they in homeschool?
yeah.
Does she actively make them do homeschool?
I don't think she does because they can barely read and write and they're 12 years old. They're going to be 12.
How much is homeschooling per year for the both of them together?
About $2,500
Okay. Per year?
per year, yes,
Okay, and that's $208 a month. Is that fair?
yes.
How much are you paying for her car insurance per month?
About $95,
Okay. And how much is your child support? Is it $1,460 a month?
yes.
Okay. Judge, if I may approach,
May.
break down an accurate depiction of how much you are paying per month for your wife's expenses. Is there anything I've left off that you can think of?
What's the basis of your objection?
Plus,
No, we've created that document for today. It's just like an income and expense statement.
Well, it's just, I mean, routinely in court, we utilize documents that are reflecting and interpreting what the parties say. And a perfect example is the income and expense statement, which technically could be hearsay, but is also used to allow the parties to testify and have some document that helps the court to understand it. Overrule the objection. It's not being admitted to prove the truth of the matter, but rather to reflect what his testimony is.
Is there anything on there that you can think of aside from your, are the debts you owe from the marital dissolution agreement requiring you to pay debts, are those actually included?
no.
Okay, how much are you paying towards those per month?
I had to quit paying them. I had to get a debt management because I couldn't pay them. I had to get a Achieve debt management. I pay them like per month.
And how much are you paying per month for that?
I have to pay $400 a month, and then they disperse out.
I may approach so that he can write that down.
All right?
are you paying $400 in addition to the $900 you're required to pay monthly to the wife?
Yes,
Wife retain all of the personal property as a result.
yes,
Mark is next in order.
Are you currently making at best between $6,500 and $7,500 per month?
Sustained.
I'll give him his pay stubs. I've got those. That's fine. How are you paid? How often are you paid?
every 2 weeks.
Okay. I may approach him.
You may.
Copies of your pay stubs for the last couple of months. I don't know.
Yeah, 6 months.
Okay. And in those pay stubs, are you paid biweekly?
Yes,
What your current gross earnings are on what were your gross earnings for what were your state earnings for 2024?
80,157.56.
Okay, and were those your gross?
Yes,
Okay. What were your net earnings?
70,668.83.
And after you paid your wife,
No, my mom's been paying my rent.
that's
Marcus is next in order.
when Mr. Hawley said that in his opening that you intentionally are making less now, have there been periods of time in the last 5 or 6 years where your income has dipped down below 80 and then come back up?
Yes,
Is this a copy of your earnings each year?
yes, ma'am.
Okay. And if we could go through, for example, in 2020, what were your earnings?
45,116.19.
Okay. And in 2019, what did you earn?
94,731.47.
Okay. And in 2021, what did you earn?
85,659.38.
In 2022, what did you earn?
77,388.90.
Okay. And so by looking at this, is your income always going up from year to year?
No,
Judge, I'd submit this.
The exhibit 4.
And in the final decree and MDA and child support worksheet, did Mr. Hawley have you written down as $120,000 a year?
yes,
Okay. In any of those monthly income totals, did you make $120,000 a year?
no,
Forgive me because I don't know the answer to this, but I do need to ask it. Are you having to pay for COBRA insurance for your wife? Or is she still on the family policy?
she's still on the family policy.
Okay. If the railroad changes it to COBRA insurance, would it be significantly more?
Yeah,
Okay. Do you know what your requirements are for switching it over to Cobra? Have you asked?
No.
In the marital dissolution, let's ask. Your wife, is she educated?
Yes, she has a bachelor's degree.
Okay. And is she able to work outside the home?
Yes.
Okay. Are your children old enough to be left at home alone? How old are your children, sir?
They're 11 and 9.
Okay. And are you a proponent at this point in time of potentially public school based on the fact that they can't read?
Yes.
Were you a proponent at the time of the final entry of the final decree of getting them in public schools?
Yes.
Pursuant to the final decree, and it's not written on that yellow sheet, so it'll be in addition to that, are you required to pay medical bills for the kids?
Yes.
Okay? And that's okay. Do you need a minute? Are you required, you're required to pay medical bills? Are you required to pay dental bills?
Yes.
Okay. Has she been sending you medical and dental bills?
Yes, whenever they need it.
Does that number fluctuate so that you can't necessarily put an exact number on your monthly amount for that?
Yeah.
When was the last time you paid a medical bill that you can recall?
Probably been a couple months. They had a dental bill. There's $106 and then a medical bill.
Do you currently owe the Internal Revenue Service for debts acquired during the marriage?
Yes.
And how much, to your knowledge, do you currently owe the Internal Revenue Service?
$6,900, but it could be more because I haven't been able to get my taxes done because she won't give me the paper, my son's social security number. Or I asked her for it and she won't give it to me, so I can't even get my taxes done.
Okay. And have you requested, strike that, Judge? Has the wife manipulated you or done anything to make you feel badly in the eyes? Strike that. When you have communication with her about paying these bills, does she call you names?
Yeah.
Has she withheld your children when you are unable to pay her full amounts?
Yes.
Okay. When was the last time she did that?
We're dealing with a Rule 60 motion. How does this testimony relate to the issues in a Rule 60 motion?
It just goes towards fraud and misrepresentation. It's part of an ongoing withholding children in order to induce instructs him to sign.
I would agree. Sustain the objection. It's not relevant to the issue before the court at the moment, so.
Okay, I'll move forward. Are you required to pay her car registration and stuff too, or is she taking care of that?
I did last time.
And what bills, if any, is she responsible for?
Nothing.
Now, when you say nothing, is she paying for food for the boys?
Yeah, with the money I send her, yeah.
Included in the utilities, are you paying the trash service bill?
Not anymore.
You able to pay the trash service bill?
No.
The November 7th. You receive text messages from her regarding signing the documents.
Yes.
Judge, if I may approach.
You may.
Had she taken your bank cards and credit cards from you?
She didn't take them, but she has a way to go into all my stuff with my emails and stuff, and she uses it that way.
Was she using your card at that
Those are baseball cards.
time? Okay. Did she take your card?
Yes.
Okay. On what date was that?
November 7th.
And what text message?
Oh, this one she broke into my place I was staying, and she took a gold, silver, cash. I collect a lot of baseball cards and sports cards, and I had about $15,000 worth of cards she took out from me whenever she was in there. So this one I filed a police report. The deputy come out there, and he had to go get them from her. Carrie, you have 30 minutes to bring my cards back to me. I'm bringing the police to the house if you don't. Now you're stealing from me. My friend called me while I was at work and said, "Is there any way she should be at your place?"
I don't quite understand. Are you reading me a text message between you and her?
Yeah, this is a text message I sent to her. I was telling her that I'd called the police and that she had 30, or I was going to call the police, and she had 30 minutes to
What
bring me back.
portion of this is hearsay? All right. The objection is withdrawn.
Someone someone had told you that she was there and you were repeating it.
Yeah, my friend called me when I was at work, and he said, "Is there any reason why she should be at your place?" And I said,
Can I object to the friend?
"Says it right here."
Well, hearsay is a statement made out of court that's introduced to prove the truth of the matter asserted in the statement. Not every statement that's made is hearsay and excluded by the hearsay rule. It has to be as to what's the purpose in introducing it. What is the statement?
The purpose in introducing it is, you told me you were here. The only purpose in introducing it is, had this conversation with her to return the cards that she had taken.
Overrule the objection.
Now, what did she say to you? Just read that.
Michael, stop playing games.
And then what else did she say?
I've logged all our cards. If you sign the agreement that you already agreed to, it won't matter. But if you decide to change what you agreed to and waste thousands of dollars in court, the judge will see all your assets. I don't want to argue and fight, but I will not be manipulated anymore. The Lord knows what you're doing and will take care of me and the boys no matter your actions. I really hope you can start thinking about them before yourself.
And was she threatening you about the cards in this statement if you didn't sign the agreement?
Yeah, she was going to sell them.
What did she say there?
She always just says, all you do is lie. She calls me a liar over everything. You're just a liar.
On November the 11th, had you stopped talking to her about the agreement?
Yes.
Okay, and what did she text you?
She said, you understand that refusing to even talk or look at the agreement and parenting plan is just wasting money, since the court will require mediation before anything, which through lawyers and a mediator will cost a lot of money. But just working it out costs only the filing fee and editing fees. Then if we go past mediation and get to court, all your lies will be exposed and the judge won't look favorably on you. I have piles and piles of evidence of your lies, and all the evidence can be backed up, even more with subpoenas for your FMLA days you mark off, personal days, vacation, everything. Then your work may open more investigations about your misuse of FMLA. And there is the possibility of the judge referring your illegal Jersey sales to investigators. Selling those to that store along with everyone else is highly illegal. I even showed you that guy who was arrested back when I was begging you not to sell them, begging you to stop. You agreed to stop and never did. Please think about just working things out and stopping your illegal behavior, along with other stuff you are doing. The boys need a godly dad and need you to think about them before yourself. Think through how your actions will affect them and their lives. They need stability and to not be brought into this like you have been doing. It will be hard to see them with your already bad schedule if me and the boys have to move away. They won't see their cousin Abe much as well. I don't know.
Don't
That's
go
a
to
different.
that one yet.
Okay.
So in this text message, go ahead, Judge.
All right.
On the agreement, she was threatening to have you investigated with your work through FMLA, and she was threatening to move away with the boys. Is that correct?
Yes, ma'am.
Okay. Are you a godly man?
Yes,
Okay. Has she tried to use that as a weapon in this case?
yes,
Okay. And in this text message even, does she bring up widely banned and taken care of?
she always does, yes.
Okay. Judge, I'd submit that as the next one. Judge, if I may have one moment, I've got to find another text message.
Well, let's take our mid-morning recess. It's 10:30.
Thank you. Judge, I'm going to be done with the text messages. I thought I could be if we
All right,
got done. I'm going to approach him quickly, and then I will be done. We're going to do parenting plan, go over it.
Mr. Holly, your client, Ms. Grammon, had entered the waiting room on that. You might want to let her know that it's been reset, so. Go ahead. I can send her a message on chat as well. All right. All right.
Yes,
Page 4 of your permanent parenting plan, in order to calculate child support, what number do they use?
$10,000.
And is that a misrepresentation of how much money you pay?
Yes,
Have you ever, in the history of working for the railroad,
no,
that number, would you have had it corrected?
yes,
Also required to maintain a life insurance policy.
yes.
Okay, does that come out of your paycheck?
Uh,
Out of your gross paycheck numbers?
It's separate.
And are you having to pay that in addition to the expenses you got listed on that?
Actually, it does come out of my check. I'm sorry.
Okay.
Yeah, 'cause
Does it come out of your gross amount on your paycheck?
Yes,
Okay. In paragraph 5 on page 3, bottom, the other expenses that you're required to pay all equipment, school books, any and all extracurricular activities, homeschooling, travel baseball, and travel basketball.
yes, ma'am.
Okay, and then going down to paragraph 6, it says that your children play travel ball and that you would pay all gate entry fees for the mother. Travel ball tournaments that are within an hour and a half away from the home, from the mother's marital residence, required to pay for the hotel rooms for those tournaments. Is that correct?
Yes,
Okay, and is that upwards of $700 per tournament that you're having to pay?
Back to the leading judge.
How much are you having to pay?
Sustain the objection.
For hotel rooms?
they're about 250 a night.
Okay, and how many nights does she generally
It's usually just the one night.
And are you having to pay those, how often during a baseball season?
Probably about five times.
Now, the mother has maintained until recently stating that she doesn't have an income, is that correct?
Yes,
And her income was imputed in this parenting plan, is that correct?
yes.
Okay. Do you know why she would be claiming the minor children on taxes if she didn't have an income at the date of the entry of the parenting plan?
No,
Okay, was the mother given the ability to claim the minor children on income taxes when she did not have an income?
no.
Taken in burdens, why would she claim the children? And why would this have her claim minor children she did not have an income? Why would he sign that thinking that was appropriate? That's absolutely mistake, inadvertence, and fraud.
I mean, he did sign it, and.
Turn your microphone on. If you're going to stand up and object, just turn that microphone on so it make sure it records.
Oh, there we go. The light was on. I'm sorry.
Now, go ahead.
Oh, well, again, we're into the issue of taxes in the parenting plan. I guess I'm objecting to the relevance because I don't see what that has to do in the formation of the MDA in the parenting plan when he did sign it. What any of this really has to do with the formation of it to fraud, inadvertence, excusable neglect, misrepresent, all of those things. It's a situation where he signed it. And we're where we're at today. But what does that have to do with the formation of the fraud, misrepresentation, excusable neglect, and misrepresentation on November the 7th or November the 13th when he signed it, I'm sure.
Part of the assertion here is that he was never provided the documents, that he signed the signature pages, and he's testified that he was not provided the documents, that he simply signed the signature pages based on representations made by the mother. My position on the tax credit is that had he actually seen that in the parenting plan, which is what he's testified to, he wouldn't have signed it because it makes no sense for her to claim 2 minor children when the parties have tax debt and she doesn't have an income.
I'm allowing the introduction of this testimony to, and for the basis of corroborating his testimony that he didn't see the agreement and only signed the last page. I'll accept it for whatever weight that has on that. So, overrule the objection.
Mr. Dunham, had you seen that she was claiming the minor children for income tax purposes when she didn't have an income, would you have had Mr. Hawley's office change that?
Yeah,
Okay. And at the time of the entry of these agreements, you actually had income tax debt, is that correct?
yes,
Which claiming the minor children would have helped with that debt, is that correct?
yes.
Aside from the $160 in equity in the marital residence that she had, did she also receipt about $30,000 in gold?
Yes,
Okay. In the division of the personal property, did she get to keep your golf cart?
he kept everything, the golf cart, the trailer, the storage building, and now she sold it.
Only sold some of those things while this is pending.
Yes, like about 3 or 4 weeks ago, she sold the storage building.
Okay. And in exchange for all of those things, what did you walk away from the marriage with?
Nothing.
Okay. Did you get to keep your baseball cards?
I did get to keep my baseball cards.
And how much are those worth?
Probably $30,000.
Okay. And so, going backwards, was she allowed 10 years to refinance the marital residence and the marital
That's
dissolution
what it
agreement
said,
also?
yes.
Okay. Is that inhibiting you from getting another place of your own?
Yeah,
Okay.
I couldn't pay for it anyway.
Okay. In your mind, is she able-bodied and capable of working, maybe even more so than you are?
Yes.
Okay. Judge, that's all.
Mr. Hawley?
Yes, sir. Not Mr. Dunham, I'm Reese Holly. Um, I'll ask you a couple of questions about having a lawyer at the time that you saw the paperwork or at the time that you executed the paperwork, let's put it that way. You hired Ms. Roberts, correct?
Yes.
And at the time that you had signed this document on November the 13th of 2023, you remember that's the date that it was signed, correct?
Mm-hmm.
Is that a yes?
Yes.
Okay. So at the time you signed it, Ms. Roberts was representing you, is that accurate?
Yes.
So had you sent her a termination letter?
At the time that I signed it?
Had you already sent her the termination
No.
letter?
No.
Do you remember what date you sent her the termination letter?
I don't think I ever sent her a termination letter. She called me after I'd already signed it because of the stuff that I'd gone through with her taking my stuff. And I hadn't been able to get a hold of Miss Roberts for about 3 weeks because of the illness she had. And, so when she finally did call me back after I left her message and about 3 or 4 messages, she finally called back. And when she did, I told her I didn't need her services no more because I already signed the paper because I couldn't get a hold of her.
Judge, if we may all approach just the group, have a discussion.
All right. Question you asked was he represented by Ms. Roberts at the time he signed the agreement?
That he had talked about termination.
Depends on when. Ms. Roberts never made an appearance in this case, though, did she? The complaint was filed November the 20th of 2023. There is nothing subsequent to that, no appearance by Ms. Roberts until the final decree was entered March 19th of 2024. There is no. Oh, she had a separate complaint?
And so if he.
Well, let's find out. Can you get me the file? There was another file that Ms. Roberts filed in Dunham versus Dunham. Let me review that file. Let's get that file and let me look at it. we're going to stand a recess till we get the other file that's being mentioned. And for the record, we'll state that Ms. Roberts filed a complaint for Mr. Dunham for divorce on November the 13th of 2023, which was 7 days prior to the complaint filed by Mr. Holly. On that same day, she filed a proposed parenting plan, and then she filed a motion to adopt the proposed parenting plan on that same day as well, and set it for a hearing on the 7th day of December. Then she filed a notice of non-suit on, looks like that complaint was served on Ms. Cara Marie Dunn on November the 15th. But then there was a December the 7th notice of non-suit that Ms. Roberts filed. So the case that she was representing him on was concluded on December the 7th. Now, this marital dissolution agreement that we're at issue over appears to me to, according to this, who have been filed on November the 13th of 2023, which was prior to the dismissal of the case pending that Ms. Roberts had. And in fact, I think it was on the same day that she had set the notice of a hearing on. Now, the question of whether or not he had discharged her prior to that time with a notice of dismissal or a notice of termination is the issue that, I mean, it is and it isn't. If he says he's discharged her prior to that November 13th, then there's no real ethical issue. If he had not discharged her prior to signing that, then there could have been an ethical issue that would have to be investigated. So the question becomes, do we need to inquire of Ms. Roberts before we go any further as to what the date of termination, or does your client know offhand the date of his termination letter?
What, did you terminate Ms. Roberts' services before or after your time?
After it.
And I think you signed that complaint prior to the time.
Yeah.
Well, the issue is the service was on.
No, but Mr. Holly said he was aware that Ms. Roberts was representing.
Oh, no, I never said that. When she got served was the first that, I know Ms. Dunham had heard of it, and then when she brought it by my office sometime later, was the first that I'd heard of it, and Ms. Roberts and I had several discussions about the whole thing. Well, that's what I'm saying. I know, it said the 15th is the date that Ms. Dunham got served, and he signed all this stuff on the 13th. We had no knowledge of Ms. Roberts' representation.
November 15th is the date of service of process, which is 2 days. I'm sorry, what?
I think Ms. Roberts had communication with Mr. Holly. We might want to check.
Well, let's take an early lunch and let you all investigate that, because it does become an issue, obviously, the validity of an agreement that was signed outside the presence of a lawyer that was representing without her knowledge and consent may very well be invalid on its face. So,
Well, may I?
sure.
She had noticed on the 15th. That was the first time that Ms. Roberts really made any sort of knowledge to Ms. Dunham that he was even represented at that point. We testifies to when she let my office know, but Ms. Dunham didn't know anything until the 15th.
No, there are text messages right here. She knew. She communicated to him about Ms. Roberts, telling him to fire her.
I think he was telling everybody that he had a lawyer, and there's a lot of text messages that say, no, I don't want my lawyer to do this. I've reached an agreement, and this is what I want to sign. But there was nothing filed by Ms. Roberts until the 15th.
But what's important is if you're the one that brought this up, if he had a lawyer at the time, it had to have gone through the lawyer.
I would agree. We're going to find out what the status of his lawyer was over the lunch hour. See if you can contact Ms. Roberts and find that out, or be prepared to address that issue when we return from lunch. But if he had a lawyer, it is unethical and therefore would invalidate an agreement that was signed by him outside the presence of his lawyer. And that's just the issue. That's the whole purpose of having a lawyer and having the ethical obligation to only deal with that lawyer, so.
Well, if I may-
On November the 11th, he tells her,
On what day?
November the 11th, he tells her, okay, Heidi said the lawyer I got could do it. He tells her. He had a lawyer.
Well, but it's the notice situation. I mean, there wasn't anything filed by Ms. Roberts until the 15th. If he says he has a
It was filed
lawyer,
on the 13th, served on the 15th.
well, the notice is on the 15th as to when we got served, or Mrs. Dunham got served, rather, let's put it that way. That's the only time that she formally knew that there was a contested divorce in play. And a lot of times it's, people get lawyers to look over paperwork and do those types of things. And he could have taken that, my point is, on the 13th, if he had have retained Ms. Roberts, he could have taken that paperwork to her, but he didn't choose to do that. He chose to go down to the UPS store by himself and sign these documents without, and again, there's not been any filings by Ms. Roberts beyond, even on the 13th, but there's no notice until the 15th. So even
Right,
before that,
I have
don't think
the
it's-
factual basis that I understand what it is and that the arguments that both of you are making. And I will consider that in my ultimate ruling. I would simply point out that this marital dissolution agreement that we're in contention about and the parenting plan were both signed on November the 13th of 2023. The complaint in this case that Mr. Holly filed was not filed until November the 20th of 2023, which is 7 days after the signing of those documents. So there was no pending case in this court other than the case that Ms. Roberts had filed on the 13th when those documents were signed. So.
And those
let's go
did just
forward.
cross in the mail.
Pardon?
For the most part, those were doing without Ms. Roberts or I, neither one really understanding what was going on with each of the parties. But that's part of my line of questioning with him, is when did he actually retain Ms. Roberts? What was his
I'm going to let him
all
question
those-
it. We'll deal with it in the
And
ultimate.
respectfully, Mr. Hawley and I had a conversation. Mr. Hawley earlier about everything he knew about Ms. Roberts. So it's disingenuous for him to get up before the court and say he didn't know Ms. Roberts.
No, I did.
I call it like I see it, and I'm
Oh, at some
not
point I
gonna
did.
let an ethical obligation pass on this.
No, this is not unethical. Believe me, if it was, Ms. Roberts would have well raised it at that time, because it was her client that was in the middle of this.
Her mother was dying. Like,
That is what Mr. Dunham has testified to, that he discharged Ms. Roberts because he could not reach her and contact her because her mother was in the hospital on her, essentially, the last days. But Ms. Duke, I am aware of your contention regarding this. I will weigh those things when we make the ultimate decision in this case. But I'm going to allow Mr. Hawley to go forward with his line of questioning.
are we taking a break for lunch or go ahead?
No, I don't think there's any reason to go break at noon or thereabouts. So. Mr. Hawley, you may continue.
So when did you retain Ms. Roberts?
3 weeks prior to signing the papers.
Okay, so 3 weeks,
Scoot up on, pull that microphone base towards you. You can, there you go.
All right.
so 3 weeks prior to,
I would say probably the 1st of November.
the time you signed these documents, you had an option, if you wanted to go and see Ms. Roberts, is that correct?
I tried 3 times, and I tried to call. I left her messages, 2 or 3 messages. She never did call me back.
Okay. But rather than wait on Ms. Roberts to get back with you, or even go hire another lawyer, your option was to, with Ms. Dunham, sign these agreements, correct?
Yeah, because like I said, she broke in and took a lot of my stuff, a lot of my valuable stuff, and I just felt like I had no help. I had nowhere to turn. I didn't know who to talk to. When she took all my stuff, then a couple of days later, whenever she said, if you just sign these papers, so I did.
Well, again, you're telling me that you retained Ms. Roberts some 3 weeks before you actually signed these documents.
Yes.
And then again, at the time you signed these documents, it was your position that you were terminating Ms. Roberts and you were going to sign these documents for whatever reason.
I didn't know then. I just knew that I couldn't get a hold of her. And that's after that happened. The day later is whenever after she took my stuff, that's whenever I agreed to sign the papers.
And did you talk to Ms. Roberts at all after that?
She called me 3 days later.
And you're aware that you could have filed something to set aside the MDA or set aside the parenting plan based on your signing that with
didn't know.
knowledge of a lawyer? I mean, did she talk to you about that?
No, actually, she wrote out the paperwork, had all this stuff totally, had joint custody. She had all the stuff where I would get the house and I might be able to move in the house because I had been paying all the bills. She had all the stuff and the parenting was going to be even. And she had it all wrote out. She just, whenever her mom got sick, I guess, she just never did file the paperwork. And I kept on trying to figure out what was taking so long. So I tried to call her and I'd left messages and couldn't get a hold of her. And she never called me back. And then after like 3 weeks after took my stuff and all that, that's whenever I finally, she called me after that happened. And I said, I already signed the paper. I couldn't get a hold of nobody.
And did y'all talk about, again, you have a right to set aside the MDA and parenting plan?
She never said nothing about that. She was pretty upset. She just said that I was stupid for what I did, pretty much. And I said, well, I didn't know what else to do.
And you talk about she had all your stuff. You're talking about the baseball cards, right?
No, she took $1,200 cash, baseball cards, some silver, some gold that I had, ammo. She took a lot of stuff.
How long were y'all married?
12 years.
And to be fair, a lot of the baseball cards you had gotten during the marriage?
No, I've had those since I was probably 25.
Okay. She's going to testify there were a lot of the baseball cards that were gotten during the marriage. Is she
Some of them
inaccurate about that?
Some of them were, but
Okay.
not all of them.
The $1,200 in the bank, was that marital money?
No, it was just cash I had in my in a safety deposit box that she took.
How long had you had that cash?
My mom gave it to me a couple weeks earlier because I had no money.
But it's money you had gotten during the marriage?
No, we'd been separated for 6 months.
Legally married?
We were married still, yeah, but we were in the process of all this.
And you said the $1,200 in the baseball cards, what else was there?
Some silver
Silver?
and some ammo, like ammo for gun.
Did you ever get the silver and the ammo?
No,
Was the silver and the ammo, was that gotten during your marriage?
yeah, I'm sure it
Let me
was.
interrupt you. Are you talking about silver or gold?
Silver and gold,
Silver and gold?
yeah.
Yeah.
So both, and that was when you're referring to the precious metals or whatever, and you make, one time you say gold, the next time you say silver, is that because they were all together?
Yeah, it was like I had like some Trump silver coins
Okay.
that I'd gotten over the years, and then we had some gold that we'd gotten over the years.
All of that was in one place, and that's what you're saying was taken?
Yes,
Oh, okay, I just want to make sure. And you testified earlier that that was worth $30,000?
well, yeah, we had $30,000 worth, and we were supposed to split everything up.
And it's baseball cards, right? Just 30,000 in baseball cards?
No, that's
He said 15
15
earlier.
in baseball, about 30 in gold and silver.
Okay.
Okay. I just was,
And we just
because
never
that's
did
been
it.
interchangeably used, one time silver, one time gold. I apologize for interrupting, but I was trying to make sure of what I knew. So.
I'm sorry, I didn't say it
No,
right.
that's all right, go ahead.
And the baseball cards you got back?
Yeah, the police officer, the deputy, got the cars back for me.
No charges?
No. Well, like you're saying, the deputy told me that since we're still legally married, that I couldn't really do nothing about it. I guess because even though I was on a separate property in a separate place, he said since we're still married, she was able to come and do that. But then I talked to Detective Phillips, and he said I could still file charges. So I don't know.
So When you signed this agreement on the 13th at the UPS store, I want to make sure I'm clear about this. Your testimony is that you met her at the UPS store and you went in and signed just the signature page alone, and then you left.
Yeah,
Okay. And you had the boys with you when you were at the UPS store, and that was kind of an exchange time. They went with
Yes.
Ms. Dunham, correct? Mm-hmm. Okay. So, I mean, she wasn't withholding the kids when you signed the agreement now, was she?
no, I had them that day.
You had them. Mm-hmm. And you met her at the Compassion Church building prior to going to the UPS store, correct?
No, I met her at a park. We talked at a park, and that's the changes you said that were made.
Was that near a park? I mean, was that near the church?
He wasn't done speaking, or he can finish. He was saying in the changes that you made, and he was going on, but was wrong.
Let him finish his answer before he asks the next question.
Yes.
Yeah, it was a park, at Buckner Park. We met at Buckner Park, and but she would never let me see the paperwork. And she just said, "Oh, we'll just make a couple changes, and I'll just go through the paralegal at your office." And so she just made a couple changes, and then she said I could have the kids after that. And that's whenever we went to the UPS store. And
So when you say make change, you're at the park and make changes, what changes were being made?
I'm not sure, she was just making changes to, but I was like, I don't think that that's right. And so she made a couple changes to the paperwork, but I never ever got to see the paperwork. Just whatever she made changes with the paralegal. I can't remember what it was, maybe
But
the
when you were, I'm sorry.
amount, I don't know.
But when you were at the park and you're discussing the changes, my question is, what changes were made on that day? Or what changes were made at the park between the two of you?
I'm not sure, we were just talking about all the stuff, because after the stuff that had already happened, and with Miss Roberts and everything, we started talking about the stuff, the decree, and there are certain things that I was like, well, that's not right. I'm not gonna sign nothing. I mean, something's gotta happen here, change it money-wise. And she said, well, she would just be like, well, this will happen, like the parenting. Because I wanted joint custody. No, you're not getting joint custody. So then it was like, well, I'll work with your work schedule. We'll just say Tuesdays, but then we'll work with your work schedule. Mm-hmm. Well, now she won't even work with my work schedule. It's stuck with Tuesday. I mean, now she won't even let me see my kids if I have my schedule goes week to week.
Is it
I might
fair
have a Thursday off, and then she's like, no, you're not seeing them.
But is it fair to say at the time you're talking at the park, you just brought it up, that you talked about making a change that you get to see the boys on Tuesday?
No, to where I could see them more often or work with my schedule, because my days off go week to week instead of like a normal work schedule. So I was like, I can't say I'll be off Tuesday. I could be off Friday.
But then go ahead.
So I'm just saying, there's something like that, change like that, like my work schedule, because I know how she can do. She might not let me see my kids. Once it's already done, she might say, well, which is what she's doing now. Well, you said Tuesday. Well, if you're not off, you're not seeing them. And all I care about is my kids.
But then while you were at the park, you were familiar with the parenting plan enough to discuss the days that you were going to be with the boys.
Yeah, because it's on her phone. She's like, well, here's what it says.
Okay.
But like I said, I never saw the paperwork though.
So your testimony is you went to the park, Buckner Park, y'all did discuss changes. Mm-hmm. You admitted
Yes.
You did know about the changes to the parenting plan with the boys and the schedule. And she was going to purportedly go have those changes made to the paperwork. Was there any other changes that you discussed?
Not that I remember. I know it's mainly about the kids, because that's the most important thing to me. And she actually called your paralegal right whenever we were there, and she made the changes then. I remember right.
Okay. So y'all negotiated changes and they were made to the paperwork, as far as you knew.
Well, that's what in the paperwork, I told her I wanted joint custody, but then she said that, we'll just put Tuesdays and that, she would work with my work schedule, like I could see him more often. And, so that's what she made changes to it because it was just one day. Now it was actually where I could see him more often.
And
Now she won't.
you made other changes, but you just don't even know what they were. You can't remember.
I don't remember. I think it was just mainly that because I had a problem with not being able to see my kids.
And of course, that entire time you're talking with her at Buckner Park, I mean, you knew you had a lawyer that you would retain that you could take this paperwork to, correct?
I did, but I couldn't get a hold of her.
Well, and you did get a hold of her. It was just sometime after.
She got a hold of me.
May.
Yes.
And ask you if you recognize that as well as text messaging between you and Ms. Dunham.
Yes.
And I didn't put them together, but I should have. Those actually kind of go together, do they not?
Yeah, they do.
All right. So starting with did you want to come to the Compassion Building? Is that you texting or is that Ms. Dunham texting? Let the court know that.
That's probably her.
Okay. And what's your response to that? Can you read it?
Yeah, I'm trying to think. I can't tell if that was me or her. It says, okay, I have to get a couple of things ready and take a shower. That might have been her.
Okay.
I'm not sure.
And then what's the next text?
Okay, let me know when you're on your way. Okay.
And everybody agrees with that. And then the next text after that, that's at 10:35 a.m., according to this, says, I'm on my way.
Yeah.
And it says, let me know when you get here. That's one of you saying that, correct? And then basically it's okay, 10 minutes, and then it says, I'm here. Is that right?
Right.
Okay. And then that kind of leads everybody to believe you're at the Compassion Church building, correct?
Yeah.
Does that jar your memory to know you were there?
I'm thinking that we talked at the Buckner Park maybe a couple days prior, and then this was the day we went and met the UPS.
Okay. and this is the day we're talking about, the day that you were at the UPS store and doing all that. You actually met before that at the Compassion Church building.
I think I met her to take the boys there.
Okay. But I mean, I want to make sure that's a change in your testimony a little bit. You're remembering things based on the text message. But
Yeah.
now you're at the Compassion Church building, correct?
Yeah,
All right. And then, after that, and on November 13th at 1:41, the text is, "I'm heading to the UPS store," correct?
yes.
And according to you, you don't know who that is. It's one of you, but you don't know who it is.
I think that's me.
Okay. I think you're right. Up at the top, it says Michael O. Phone, correct?
Yeah, yeah.
All right, and that's you, correct?
Mm-hmm.
Is that a
Yeah.
yes? Is that a yes?
Yes.
Okay. And are you aware that when it says that up at the top, all of your text, whoever is up at the top like that's on the right-hand side?
I didn't know.
Okay. Nonetheless, you do believe that was you saying, "I'm heading to the UPS store"?
Yeah, we met at the UPS store, yeah.
Okay. And it says, "Okay, you're almost here." Goes on to say, "Yeah, basically I'm inside." Somebody else says, "Okay." Y'all going inside the UPS store to sign everything at that point, correct?
Yeah,
Fair enough. And I want you to look at the times when you're talking about being at the Compassion Church. You're at 10:35 a.m., correct?
yes,
Is that fair? And then at the UPS store, based on everything that's going on here, you're at 1:41 p.m., correct?
yeah.
Got it. So is it fair to say from the time you were at Compassion Church, talking about all these changes, you knew these changes were going to be made? I mean, it looks like you had from 10:35 to 1:41 p.m. to think about those changes, at least in your head.
We never talked about the changes there. That's what they do, their homeschooling. The boys,
I'm sorry, you've got me.
the kids, they do their homeschooling there. We didn't meet at Compassion to talk about any of the changes. That was prior to that.
Okay, so that was a couple of days before that. Your testimony, then you're at Buckner Park talking about changes.
Yes,
So you actually had a couple of days to think about the changes, not just a couple of hours. Is that fair enough?
yeah, I mean, I already said that, because I couldn't get a hold of my lawyer, I didn't know what else to do, so I already said that you had to sign them. Didn't know what to do.
If I've kept up with this correctly or not, I think we're at Exhibit 7, or we're at 8? 7. I would ask this to be collected, Exhibit 7, these text messages.
What?
Did you, when you were terminating Ms. Roberts, did you ask for a refund?
I did.
Okay. Kind of, is it fair to say you weren't wanting to waste the money on an attorney if you could make an agreement?
No, what happened was, I just wanted to get half my money back because after all that had happened, she'd already wrote out all the paperwork to have everything done the right way, but then whenever nothing ever happened, and she called me after everything was signed, I just asked her if she'd at least refund half of it. She wouldn't do it.
Well, is it fair to say that you were getting a half, or at least asking for half a refund to get your money back rather than go through the process of the divorce and all the additional monies, not only that, but the additional monies? Is it fair to say in your mind, you're terminating Ms. Roberts to save money to make this agreement.
It didn't have nothing to do with that.
But you did ask for half your money back.
Yeah, because she filed, I figured since it was filed as contested, and from all I've ever heard was that was like $5,000, but non-contested would be half of that. So I just figured since I hadn't been able to talk to her, get a hold of her after all that stuff happened, whenever she finally called me and I'd already signed it, I just was asking half because it was not contested. Because it's not contested instead of contested.
When did you, if you can recall, when did you first tell Ms. Roberts that you had signed this paperwork?
When she called me.
So at the time you're calling and leaving messages, you didn't say anything about that?
No, during that time, I didn't know what happened with her mom. I just thought she just wasn't able to get to me. So I told her about her breaking in and taking my stuff, and I said, I don't know what to do. I have no way to pay nothing. And I said, I need someone to give me a call back. And I called her about that, and I asked her what was going on with the court case, because I hadn't heard nothing about that. So then I stopped by her office a couple of times, and she wasn't there. And after that, I didn't, and then after 3 weeks, I believe it was almost 3 weeks, she finally had called me back and said she had an illness in the family and she was sorry. And I said, well, I've already signed the paper. I didn't know what else to do. I'd given up.
And then at that point you were saying, I'd like to have half my money back. Was that conversation?
Yeah, when she called me back, she said, I can't believe you signed the paper. She said, I said, well, I didn't know what else to do. I've left you message after message. I said, and then after we talked for a little bit, I just said that I didn't need her services no more. And she said, well, let me take a look at the paperwork first. And I said, okay, we'll take a look at the paperwork. And then after she did that, that's whenever I asked her if she could refund me half the money back. She said, no. She said, I'm not going to be able to do that.
Let me just be clear and make sure I get this under oath. Is there ever a point in time that you ever saw this paperwork?
After the decree was finished, after the final decree was done.
Okay. So at the point in time the final decree was done, that's when you saw the paperwork?
Yeah, once the final decree was done, I saw the paperwork.
Did you get it in the mail?
Yes, sir.
Okay. Are you aware that you had time to still object to that, 10 days or so to object to that?
No, but once I looked at all the paperwork, I didn't know how to go about getting a lawyer. I had no money. I didn't know what I could do. I thought I had to come up with the money for another lawyer. And whenever Miss Roberts wouldn't refund me the money, and I'd had all my stuff taken, I didn't have no way to do anything. So once my mom was able to, they sold their house. When they sold their house, a month later, that's whenever they paid for the lawyer for me.
You may.
Text messages. Do you recognize those text messages?
Yes.
And that's text messaging between you and Ms. Dunham, correct?
Yes.
I believe that's you at the top. Can you read and if it's not, stop me, but I think it is. And if it's, Well, can you read what you put there at the very front?
Yes, where it says, I talked to Heidi.
Yes.
I talked to Heidi. She is doing some online jobs because Andy's work has been slow to help. If you could do something like that to help, I could pay the house and the utilities, then you would only need your $1,400. Then I could help with other stuff as needed.
And that was on November 11th, 11:16 PM, correct?
Yes,
All right, and then her response was to that, looks like it's November 12th at 8:59, is that right?
yeah.
Can you read her response?
So you will agree to pay for everything else you said you would pay for, just not give me the $1,400 I used to take care of me and the boys.
And then what was your response to that right after it?
Yes, that is $3,000 a month. If you just got a little job like Heidi to help, she has some information. You could probably make more than $1,400 a month. Then I know I could keep up with everything. So if my mom moves, I could at least afford something, and the boys could have both of us.
And again, your reply was on November 12th, correct?
Yes,
And her response was, I'll pray about it. Is that right?
Yeah.
Okay. So I mean, is this fair to say that on November 11th and 12th, you guys are discussing the details of your agreement?
yeah,
And at some point, you're talking about the $1,400 a month that you guys were, talking about as far as her needing for the boys and the spousal support, correct?
yeah.
Okay. So you knew that was there,
Yeah, like I said, the most important thing is my kids.
but knowing that was there, you're still, sounds like today, your testimony with the judge, you're still kind of objecting to having to pay for all that because you didn't realize it was there.
That's because I got everything taken from me. I had no lawyer to talk to. I didn't. That's why I agreed to it, because I want to see my kids.
Now, you understand my point. This is on the 11th and the 12th. You guys, my point is, you knew about it.
Like I said, I hadn't talked to my lawyer. I talked to her 3 days later when she called me after I hadn't been able to get a hold of her for 3 weeks.
And again, back to your point, you brought the kids with you to the UPS store when you signed it, correct?
Yeah,
So you were missing your kids on that day, were you?
because I got to see them that day, yeah.
Judge, if I can, I would like to move that for Exhibit 8, just one page.
All right.
And while we're on the subject of the spousal support, this money that you're talking about here in your text, are you aware that, the spousal support in the MDA is for the mortgage, the utilities, and the taxes?
Yes,
Yes, yes. And, it's not just like, we agree, fund money that Ms. Dunham has to go do nails and hair and get a new car, do whatever. She's to take that spousal support and spend it on the mortgage, the utilities, and the taxes, correct?
yeah, but it's $3,000 a month.
And the mortgage is
I
how
don't even
much?
make that.
And how much is your mortgage?
$2,300,
And how long had you been paying that while you were married?
6 months.
Because she didn't work during the marriage, did she?
No, she had a part-time job, I think.
When was the part-time job?
She's been doing like a thing with the homeschool group. She works with the homeschool group.
Fair to say it's a nominal job to begin with. She wasn't making any
No,
money.
about 8 or 10,000 a year.
Do you have any reason to believe that Ms. Dunham was not using the spousal support money to pay for the mortgage, the utilities, and the taxes for her and your boys to live in?
No, I know she was.
In fact, when you stopped paying it, or at least reduced it, let's put it that way, you were paying the amount, I think came out to be $1,400 a month, right?
Yeah, it's $1,500 a month
And then you reduced it to $750 and made that payment for a while. 2 months,
for the
3.
last 3 months, yeah.
Yeah. Then you went down to $500 a month.
Well, that's because they took my Christmas bonus and sent her almost $1,500 last month.
And because of the reductions in the spousal support payments to her from you, you're aware she got behind on the mortgage.
Yes,
And I think you've already testified to that. I just want to make clear, you're aware that she sold or had to sell some of the property she had to get the mortgage even caught back up.
yeah,
Are you aware in the MDA that you signed, if you got behind on any of this stuff, you still had an out to give her half of your, I think it's half of your 401k at the time of the divorce?
well, I have no other choice, I can't pay for all that.
Are you aware
I
that you
don't
had
have-
that option? That's my question.
I wasn't aware of that.
I'm sorry, Judge, may I have just a second? Approach.
Right.
It's accurate, this is your MDA filed November. Chance to look through that MDA, make sure your signatures are on the back and whatnot. Paragraph that I'm talking about right here. My first question is, do you recognize that as your MDA that you signed, and that you and Ms. Dunham executed on the 13th of November, 2023?
Yes.
Okay. That paragraph that I was pointing to, can you read that paragraph into evidence, please, sir?
It is further agreed that should the husband not pay the spousal support, then the husband agrees that the wife shall be entitled to half of any of all 401ks as of the date of the judge signed stamp filed of the final decree of divorce, and further, that once the wife receives her one half said 401ks, then the wife shall deduct the amount from the husband's monthly spousal support payments, and the husband shall pay any and all remaining spousal support payments until the youngest child reaches the age of 18 and graduates high school, whichever is the later.
Fair to say, based on this paragraph, even if you got behind on what you're behind on now, you've got an out to give her half of your 401ks, and she still has to use it for everything she's supposed to use it for, but at least you've got an out in this MDA.
Okay.
Fair enough?
Yeah.
Okay. So the reality of this is, you may be behind or having needs on spousal support because of, we'll talk about it in a minute, your high blood pressure or whatnot. But at the same time, you got an out here in your MDA that you've not even looked at or taken, correct?
I guess so.
I'm gonna object. That's a misrepresentation of what it says. He's misrepresenting exactly what the MDA says. MDA doesn't say that. It says she has an out. It doesn't say he does. It says she may opt to go after the 401k. It doesn't say that he can.
Well, I would respectfully disagree with that. Then the husband agrees that the wife should be entitled to one half of any and all the he agrees that she's entitled to one half, and all he's got to do is do it. And there's no way that we can void that in the MDA.
But it doesn't say that.
I just read it. Then the husband agrees that the wife shall be, and he did too, the husband agreed that the wife shall be entitled to one half of any and all 401ks.
But it doesn't say what vehicle to which that is to be completed, is what I'm getting at. It doesn't say he can tap into it.
Well, the question I have is, of course, it says if it further agreed that should the husband not pay his spousal support, Does that mean he never pays it, or he misses one payment, or what? And then the husband agrees the wife shall be entitled to one half of any and all of his 401ks as to the date of the judge signed, stamp filed copy of the final decree of divorce. And further, that once the wife receives her one half of the 401ks, then the wife shall deduct that amount from the husband's monthly spousal support payments, and the husband shall pay any and all remaining spousal support payments until the youngest child reaches the age of 18 and or graduates from high school, whichever is later. You know, I can understand how a layperson might be a little bit confused by that, but basically it says if he doesn't make a spousal support payment, then she triggers that and she gets one half of his, if he misses one payment according to that, then she gets one half of his 401k, and if she gets one half of his 401k, she deducts the amount of that monthly support payment, and then he'll continue paying any remaining spousal support payments, which means he misses one monthly payment, that triggers that. She then gets half of his 401k. He has to then continue paying the remaining spousal support payments after the deduction of that one that he missed.
But my position is, Mr. Hawley is representing to this court that it triggered him going into his 401k. The way I'm reading it, it triggers her ability to go
I agree with your
into.
interpretation. It's not something he gets to choose to do. It is a right that she's given under this.
Right.
More concerning is that it doesn't specify that she deducts all future remaining monthly support payments, and then he'll pay any and all remaining support payments. It just says she'll deduct the support payment that he missed. So one interpretation this could be given is he misses one support payment, she gets to one half of his 401k, she deducts that one payment, he has to pay the rest. I know that's not what was intended. I'm just saying that the language is confusing at best.
I just didn't want it misrepresented.
I agree with your interpretation, Ms. Duke, that it is not an option he's given, it's a right she is given under this agreement.
Thank you, Judge.
So, well, I'll save that for closing. If she was to get one half of your 401ks, I mean, you're aware that that requires signatures from everybody and that you would have to do what's called a quadro.
I guess so, I don't know.
And she never did this. I mean, you or her, no matter whoever was supposed to have done it, nobody's ever done this yet, correct?
No,
Do you have any issue with half of your 401k going toward the spousal support payments at this point?
I mean, I've got loans out on all of them. She told me to take a loan out before to pay for something. I've got 3 loans out on my 401, just trying to keep up with all this. So, I mean, she's got everything else. She can have it too.
Well, you're aware that, you can't really get a loan on more than half of your 401k. Are you aware of that?
Yeah,
So the half of the 401k that we're talking about here is still in your 401k, right?
yeah, I got a loan out for half of it.
Yeah. So do you have any issue with her getting the other half, and that would equal out the spousal support payments?
I don't guess so.
I mean, is that addressing the motion, or is that addressing your motion for contempt for not having paid it?
Yeah,
It
and I
seems
was
to me-
I think it's both.
I will say, I was going to object earlier, but he kept tiptoeing back to the motion to set aside, or the Rule 60 motion, so I didn't make that. I mean, really, he's allowed to plead the fifth on that motion for contempt. It's just, it's weird, it's so out of order. Not out of order, but it would be out of order him asking those questions, so.
I'm hearing the motion under Rule 60.02 to set aside the final decree and parenting plan. I am not going to consider the option that he may have to try to cure any contempt that he has, because until we determine the validity of the decree and a marital dissolution agreement, it seems to me that we're far-flung it. We're at the noon hour. This horse may not be deceased quite yet, but we'll continue beating it until it is after lunch.
But,
Yes.
Ms. Dunham, I'm Hillary Duke. So you agree to breaking and entering into his home and getting his baseball cards out, is that correct?
No,
Okay,
no.
okay. Well, you went into his home uninvited, is that correct?
I had access to the place.
Okay, but you didn't have permission to
I
be there?
had
Yes or
the
no?
code.
Did you have permission to be there?
I didn't talk to him that day before I
Okay.
went in.
So the answer to that question is no, I didn't have permission, is that correct?
We were married.
Okay. Did he give you express permission to be in his home, yes or no?
I did not talk to him
Yes.
before I went in.
Yes or no, and then you can explain yourself.
Can you ask it again?
Did he give you permission to be in his home on that date?
He gave me permission
Yes
to
or
go.
no?
Yes,
Okay. And on that date, you also took out of his home gold and silver. You had the majority of the gold at the house already, correct?
I did not. Can you ask one question? What was the first question?
You had the majority of the gold at your house already, is that correct?
I had all the gold.
Okay. And on that date, you took, aside from the baseball cards, you also took silver out of his home, is that correct?
No,
Okay. And you took ammo and his court documents out that day, correct?
no,
You took the copies of the court documents on that date that Ms. Roberts had drafted.
no.
Okay. And you knew what Ms. Roberts was wanting him to submit to the court on November the 7th.
No,
Got to be in the form of a question, Ms. Duke.
Okay. You knew, yes or no, the parenting plan that he wanted approved by the court was an equal shared parenting time. Yes or no?
are you asking me if, I don't know quite how you're asking this, because I did not know from any lawyer or any parenting plan.
On November the 7th, when you took documents from his home,
Oh, no, I did not.
Okay.
I did not know that, no.
you reviewed the copy of the documents that he received from Ms. Roberts, correct?
No,
That correct, it is a question.
She makes a statement, then she asks her a question at the end, so overruled.
And you testified earlier that you never knew about him hiring Miss Roberts until he signed off on the agreement with Mr. Hawley, is that correct?
no.
When did you know about Miss Roberts?
No. He had told me that he had a lawyer, but he said that he fired her. That's all I knew.
And I'm going to go on, Judge, I think. At no point in time has he earned $120,000 in the last 10 years, has he?
In the last 10 years, no.
Okay. And you agree with me that your parenting plan shows that he was making $120,000 a year on the child support calculation? Yes or no?
Yes,
Okay. And that's not accurate, is it?
it was accurate when he signed it.
Have you researched the value of your home on Zillow or through a real estate agent?
I looked at there's two houses that just sold down the road from the same builder.
Okay. I asked you a specific question.
Okay.
Have you looked at Zillow or
I
spoken
did
to a
not
real
look
estate
at,
agent?
I did speak to a realtor. I did not look at Zillow.
Okay. Did you know that Zillow values your home at $493,000?
It's inaccurate.
Okay. And you've told this court today that this is a fair agreement because he got some things and you got some things, but you understand that you got a home, $7,000 a month from him, the trailer, the golf cart, the storage building, the gold. Can you explain to me how that's fair?
I Say, okay, what was the beginning of your question? You're saying that I got,
You got the home,
okay.
you're getting
So-
$7,000 a month.
Okay, I did not get
You've got a
7,000 a
trailer, a golf cart, a storage building. Tell me how,
I don't get 7,000 a month. That's completely inaccurate. He's supposed to pay 1,500 every 2 weeks, and that's with child support. I don't get anything else. That was part of that. The trailer was a birthday present that I had gotten. He had never used that trailer. He doesn't know how to drive a trailer. That was mine. The storage building was part of the property. You know, the setup was so that I could do homeschool in there. He got thousands and thousands of baseball cards. He got all the guns. He left 2 rusty rifles and 1 handgun. So I basically got 1 handgun. He took all the valuable guns.
okay, those guns were attained before marriage, is that correct?
No, they were not. He did not have those.
And the
before.
baseball cards and collections were before marriage, is that correct?
No, only the cheap baseball cards that we weren't even talking about. These ones that are worth, 20, 30,000, whatever they are, those were all after we got married.
Okay, and you don't have any of that to show to the court today where you stole that book of cards and took your pictures? You don't have anything before this court today, do you?
I did not steal anything.
Okay. You took it, is that fair? You've already testified you took it. Yes or no?
I had
Yes
the
or no?
cards, and they went back to him.
Okay. But you removed them from his home without his permission. It's not been answered. It hasn't been answered.
Overruled.
You removed it without his permission.
I had
I
the
did
marital
is the answer to that.
property. Yes, I got the marital
Okay.
property, took pictures, and then they went back to him.
And you had multiple discussions with him about, I'm wanting you to have joint custody, but we're just going to put Tuesday and then work with your schedule to give you more time.
No, he only gets 1 day off a week. So that was not a discussion.
Okay, but when he takes his FMLA, he might have more, is that correct?
If he takes days off FMLA,
Okay, and he's used his FMLA for 3 years in the marriage, 3 years. And now all of a sudden that you guys are getting divorced, you have some issue with how he uses his FMLA?
no, we argued about it all the time.
Oh, okay. You just don't like that you can't control when he's at work and not at work, is that correct?
Overruled.
You can't control when he's at work and when he's not at work.
I told him, I don't care if you go to work or not, I just want you to make sure that you're providing for me and the kids the way that you've agreed, that's it.
And so on that list of items that I gave regarding the expenses, after he's paid you $6,776 a month, do you expect him to live off of $100 a month?
He doesn't pay that. That's not what he pays.
My understanding is that, and I just want to make this clear because I know Mr. Duke, you continue to talk about that particular amount. My reading of the marital dissolution agreement is that he's going to pay her these monies, and out of that money, the spousal support, she is required to pay the mortgage for the house and the utilities. That's the way I read it. Is that not how you read it?
No, it says he's supposed to pay the utilities and the mortgage.
Well, let's look, just because I want to, this is a continuing issue that comes up. And all right, spousal support. The parties agree and acknowledge the husband shall pay to the wife the sum of $1,500 biweekly, and the payments shall begin on the first day of December 2023 for 3 months, and then shall pay $825 bi-weekly thereafter, and continue until the youngest child reaches the age of 18 and/or graduates from high school, whichever is later, to which shall cover the cost of the mortgage, utilities, and taxes on the marital residence.
Yes,
Because-
but if you go down to the next page on 4, it says the husband shall be responsible for the mortgage payment, utilities, and taxes of the marital residence.
And where are you looking at that?
Page 4, sentence 1, 2, 3, 4, 5.
Husband shall be responsible for the mortgage payment, utilities, and taxes on the marital residence until such time as the wife can refinance the marital residence in her name only.
And the wife gets 10 years to refinance.
But
So, page 6 of that is very plain, that what he's talking about on page, what the parties are talking about on page 4, with him required to pay the mortgage, utility, taxes, that's a spousal support going forward.
I
I don't
understand
think-
that's the argument, but that's not clear.
I don't think
Then-
anything in this agreement.
I'm sorry?
Well,
I don't care what the course of I'm being required to interpret a marital dissolution agreement to determine whether it is one that is enforceable, and under the circumstances, all I'm pointing out is there's some confusion on whether or not, on how much it is that he is required to pay. Now, the language is contradictory in those two paragraphs in this marital dissolution agreement, is what I'm pointing out. And in one, it says he's obligated to pay that. And then, as Ms. Duke points out, the next page or 2 pages later, it says that he has to pay the spousal support, and out of that, she'll pay the mortgage and so forth. So it's, those two are inconsistent in my opinion, but. Any redirect? Nothing? We have just a moment, I do have a question or two. In this message that was sent on November the 11th, 2 days before the signing of this agreement, that was made as exhibit number 6. You make the statement to him as following: I have piles and piles of evidence of your lies, and all that evidence can be backed up even more with subpoenas for your FMLA marked off days, personal vacation and everything. Then your work may open more investigations about your misuse of FMLA. There's a possibility of the judge referring your illegal jersey sales to investigators. Selling those to that store along with everyone else is highly illegal. I even showed you that guy that was arrested back when I was begging you to stop. You agreed to stop and never did. Please think about just working things out and stopping your illegal behavior along with the other stuff you're doing. Then it goes on to talk about the boys need a godly dad. Do you know what the term extortion is? All right, the term extortion means that when you're threatening someone with prosecution or criminal prosecution in order to gain an advantage in a civil action, that can be construed to be extortion. In other words, threatening someone to prosecute them or to reveal criminal conduct on their part in order to gain an advantage in a civil action is where this sounds a great deal like. So, and that was 2 days before he signed this agreement, correct?
Yes, can I comment on
Yes.
that? So when we were talking in that conversation, he kept trying to tell me that he only made $4,000 or $5,000 a month. And I said, you're lying about that. I know how much you make. So when I was talking about the FMLA and all that kind of stuff, I was referring to that. Look, it's all going to come out, how much you make, and we're going to know like that you are not going to work on purpose illegally. And so then my thinking was that any judge looking at it would know that he's lying about his income because he was trying to not, pay and not have to, support me and the kids because of the income thing. So that's what that was. And then I thought, okay, if we do have to go to court because of all that, then all this other stuff's going to come out, and I don't want him to lose his job. I don't want him to get in trouble.
But all
So
of
I
that
just
has
wanted
now
to do
come
an
out today,
agreement.
right?
Yeah,
All of
it's
that's
come
now
out
come
now.
out. Okay.
Yeah.
All right. Now, you drafted the template for the letter to terminate Ms. Roberts as his attorney, and I have reviewed that. Did you sign his name to that?
No, I did not.
So you're saying that's his signature?
Came to the house, and I even texted him. I said, I have a template. If you want to come over, you can look at it and, tell me what you want it to say, or we'll just work it out. And so he came over to the house. He said, what he wanted it to say. I fixed, made it sound professional for him. I said, is this it? He said, yes. He signed it, and that was it. So I just helped him with it.
Right. Well, and the reason I was wondering is after looking at his signature on that document and his signature on the marital dissolution agreement and his signature on the parenting plan, those signatures appeared to be different, and that's why I wanted to have you testify under oath as to who actually signed that document. So, all right. I think those are all my questions. Anybody have anything following up?
Briefly, Judge. So, Judge talks about the paragraph in that text that, you were being a little forceful with him about laying out the reasoning and some of those things about the expenses and some of this stuff coming to light. So that was a couple of days before you guys signed on the 13th. And then on the 13th, when you guys signed this, when you negotiated the actual settlement, did you actually come way down on what you were asking for at that point?
Sustained, don't lead the witness.
What concessions did you make at that time on the 13th?
Oh, we took the $1,500 a month off.
Okay, and that was at his request?
Yes.
Okay. So did you hold all that stuff over his head when that was going on?
No, we didn't even discuss anything but the agreement.
Okay. And as far as that letter goes, did he ask for your help?
Yes, he asked for my help.
And again, he came over to your,
He came to my house.
Sustained, don't lead the witness.
where did he go to,
He came over to the house, and we sat at the dining table
okay. And again, that was at whose request?
at his request.
Mrs. Duke, do you have any other questions? Thank you, ma'am. You may step down. Mr. Holly, you have any other proof?
I do not.
Any rebuttal proof? We'll hear you in argument. Excuse me.
Thank closing, Judge. Action. Both parties had an opportunity to negotiate. We've heard that all day today. They negotiated. And just like any agreement, you go through points of negotiation with this and that. And it was negotiated. Both parties signed it. He had many, many chances to do other things. He did not. Fired his lawyer, see the termination letter, and he signed it. And again, this is, in my opinion, I think the evidence is clear, buyer's remorse. It's not $6,000, $7,000, it's $3,000. And you've heard that goes to the mortgage, utility expenses. If you want to, and you have the option under 60.02 to rearrange your order as well. So if that's something that needs to be rearranged, by all means, rearrange it. It's been the party's conduct this entire time. She wasn't taking this mortgage and getting hair and nails and eyelashes and all the things that we see people do. I don't know what she was doing. She's paying the mortgage, testified she was behind when he got behind. And these two boys are depending on that for their homeschool and their actual residence at this point. She was the economically disadvantaged spouse throughout the process of the entire marriage. And that was what they had set up. That was how they did it. That was what they all agreed to, was the homeschool and that kind of thing. So the amount of expenses that were in that agreement, I would argue definitely not unconscionable. That's what they agreed to, and that's what she needed and what she had to have with a $2,200 mortgage. That's in evidence. $2,200 some odd dollar mortgage, plus the utilities. And the taxes are probably going to cover that $3,000. And that'd be my position. That pretty much covers the $3,000. Then all he's got to do is pay for the boys' extracurriculars and things of that nature. It wasn't her money. This was for the children. So I'm asking for you to leave everything the way it is. Again, if you want to rework that where she definitely has to do the mortgage, utilities, taxes, and pay for it out of the spousal support, if that's unclear, then by all means make that ruling. We don't have a problem with that because that was the intention all along in those two paragraphs. But I appreciate your time today to hear it.
It's clear he had an attorney representing him at the time. Testimony was that the plaintiff in this case knew that he had an attorney representing him, and my client said that his attorney reached out to ask if service could be had. And Your Honor pointed out something that I'd pointed out early on direct, that she threatened him to sign this. It was absolutely extortion, and those were absolutely threats. He can't pay these amounts. The math is not mathing in this. It just isn't. He cannot live off the little bit of money that he has left at the end of the month. She takes some issue with FMLA. Well, she didn't take some issue with it for the 5 years they were married that he was on it. And lastly, and kind of one of the most important points, is that there's misrepresentations all over the place. The agreements, the parenting plan does not make sense. The MDA does not make sense. The parenting plan misstates what income he has. He never made $120,000, ever. But it has him as income at $120,000. The MDA is wrought with inaccuracies and contradictions all throughout it. I'd ask that these matters be set aside.
I know it's late. I'm going to take a short recess and review my notes before I come back and give you my ruling. We'll stand in recess for a short period. Any property rights between the parties. If the court does not affirmatively find that the agreement is sufficient or equitable and the cause shall be continued by the court to allow further disposition by the petitioners. If both parties are present, then they can ratify any amendments and so forth. Problem here is that the issue that has been raised is that the marital dissolution agreement does not contain an equitable distribution of the settlement of the property rights of the parties. That's the allegation. The issues that this court finds to be present are as follows: that Mr. Denham was represented by counsel, Ms. Jennifer Roberts, at the time, and he, in fact, had retained her prior to any of the execution of these documents, that he was represented by counsel, and that fact was made known to Mrs. Dunham and her attorney, and that while he was represented by counsel, he could not reach his attorney due to her mother's serious health issues, and therefore he could not consult with her, but that nonetheless he was at that time represented by Ms. Roberts. During the time that he was represented by Ms. Roberts, Mrs. Dunham, as exhibited, as I've referred to in exhibit number A6, that was made an exhibit of a text message, that the court finds that Mrs. Dunham communicated to Mr. Dunham certain threats of possible criminal prosecution that would result if he continued to resist a settlement, and that those statements were made in an effort to coerce Mr. Dunham to agree to the terms of the agreement that she wanted. There was contradictory testimony in this case regarding whether or not she actually threatened to withhold visitation with the minor children, but there was also contradictory testimony as to whether or not he was presented with the entire agreement that was drafted by her or whether he was given an opportunity to review the entire agreement, or whether it was just a signature page. He testified that it was just a signature page. She testified that it was the entire agreement. The court nonetheless finds that, despite that contradiction, that the marital dissolution agreement itself contains significant contradictory language regarding his financial obligations. That language is set forth in the agreement regarding his obligations about the mortgage that was brought up, that the husband on page 4 of the agreement, and in paragraph 4 of the agreement on page 4, it states the following: the husband shall be responsible for the mortgage payment, utilities, and taxes on the marital residence until such time as the wife can refinance the marital residence in her name only. The wife shall have up to 10 years to refinance the marital residence. That language requires Mr. Dunham to pay the mortgage and expenses, utilities, and taxes on that residence for up to a period of 10 years. That's the clear language that's set forth. In the following portions, under paragraph 6, the spousal support or alimony provisions, it states the following, that, and I'm going to skip on down rather than state that. It goes on to say that he will pay the $1,500, and I'm referring to paragraph 6 of the spousal support or alimony. He will pay $1,500 biweekly on the first day of December 2023 for 3 months, and then $825 biweekly thereafter, continue until the youngest child reaches the age of 18 and graduates from high school, the latter of which, whichever is the later, to which shall cover the cost of mortgage, utilities, and taxes on the marital residence. This court finds that that language, as Mr. Holly and his client may want to try to interpret it, is contradictory to the language that was previously quoted. There's nothing in that language that this court can clearly see that that she was going to be obligated to use the payments that he was to make to cover the cost of insurance, cover the cost of the mortgage, utilities, and taxes on this marital residence. So I find that to be a contradiction that clearly creates problems for the marital dissolution agreement's enforcement. In addition to that, the court finds that the testimony and the proof before the court is that the marital dissolution, the parenting plan in the calculation of child support was based upon an income of $10,000 a month to Mr. Dunham, and that the proof has been that there was never any time during his employment that he made $10,000 a month. And therefore, that in and of itself constitutes a fatal error to the calculation of child support. Based upon all of those facts, the court is of the opinion that the equitable situation would be to consider the Rule 60 motion. And I would quote you the Beeson versus Beeson, which is a Tennessee Court of Appeals decision in 120 Southwest 3rd, 833. In that case, the court found that there was a Rule 60 motion to correct an error in a divorce in a qualified domestic relations order in a marital dissolution agreement in a case that awarded the wife more than what she was entitled to out of an award of a retirement account that the husband had, and that was a proper application of the Rule 60 to correct that error. This court is of the opinion that Rule 60 provides a relief in this case to Mr. Dunham, and therefore the court grants the Rule 60 motion that he has filed and sets aside the final decree of divorce, the marital dissolution agreement, and the parenting plan, and reinstates this case on the accurate document, on the active docket of the court. This will draw the order that reflects the court's ruling